The problem in this being is that people who aren't generally we'll say law-abiding, but people who, you know, go out and deliberately do the wrong thing by other people would be able to then use this to manipulate the system to get off.
Sure, if they studied it and knew how to do it,
your average person who treats other people well and isn't a bad person.
So could you go to the extreme, go out and murder someone, get arrested and use these techniques to stay out of jail?
Oh, I won't answer it. Yeah, I won't answer those questions. However,
wait a
you
minute,
know, anyone can.
In theory,
in theory.
Sorry, you can't just go through all of this.
Yeah.
And
but for those people who might be listening,
out of answering a question like that.
But I don't want to prompt anyone to do anything. You can see what I'm coming from.
No, but you've got to be clear about where you're coming from. You can't sort of outline
in theory,
a like this, and
surely.
Then when you're challenged at a point that's really a bit too hard, sort of duck out of it and say no.
Okay, well, in theory, yeah, sure.
Thank you.
You could any one of us could take a gun and go and shoot someone, right? But it's not morally right to do so.
Back in the instance where you're in court and the judge wasn't asking you those questions, you're responding in a way where that you're putting the question back on him. What happens in the end of that court session?
Dismissed.
He just says, court dismissed, thrown out the case.
Yeah, because he's not able to gain jurisdiction over you. Yeah, so
but you could just do a little slip up with one word and then he's got you.
Yeah, you'd have to really work to get back out of it again. You know, if once he's got you, it would be difficult, but you could do it. But the best way is to stay out of it, and the best way is not to go to court, obviously, with good paperwork. So I'm going to just try and open up here.
I guess the you know, if people had intent to follow that path and initiate all the processes, you know, primarily for you know, let's call it antisocial behaviour, I think they'd probably find it a lot easier to do what, like, you know, criminals, you know, corporate criminals to street criminals do all the time, and just do it anyway, and just use
and just get a really good lawyer to get you off anyway.
yeah, whatever. So that's probably, you know, for them easier. Just, you know, pay some money to get the right actor to.
Okay, I've located the files now. I'm just going to open these up and read you something here. Now, this is getting back to the issue of credit card fraud and credit card debt. Now, there's no such thing as debt. I just want to make that very clear. There is no such thing as debt. This is a notice that I put together for a friend of mine who was in, as I said, $47,000 of debt, and he received back a notice to say that the balance was zero after I'd finished this. Now, this is a conditional acceptance and debt verification notice.
So he didn't have to get rid of his entity or anything.
No.
He just had to use these letters.
I basically acted as his agent.
Yeah.
And I think we did about 3 or 4 letters. So, what I basically wrote for him was this. I refer to the default notice dated 11th of March 2006 and wish to advise that your negotiable instrument has been accepted for value upon proof of claim, which may be substantiated by forwarding the following verification of debt details within 3 days, 72 hours, of receipt of this notice to the address listed below. Number 1. Proof of the existence of an account or contract in the actual flesh and blood name of John Doe, duly signed and witnessed by both parties, not a unilateral agreement, and upon which signed page there is reference to the entire agreement. Note: John Doe is an artificial entity, a limited liability legal fiction trademark, which constitutes valuable intellectual property, and all rights, title, and interest are reserved. Number 2. Proof of claim that you are the current holder of the original above-mentioned debt instrument and that it has not been on-sold to another party. Remember, I talked before about the debt being on-sold. They no longer have the right to claim. Number 3, a copy of the actual accounting whereby Bank SA has incurred a loss of the alleged debt. And number 4, an invoice, not a statement, for any amount of money allegedly owing or owed to Bank SA by John Doe. Now at the bottom of there I've got a disclaimer. So here are the things. Now I know that they can't provide any of those, and these things vary. Sometimes I like to put on there as a number 5, proof of claim that there is any lawful money in circulation backed by anything of value, because that really fucks them up, right? Can I say that on the air? Fuck up. Yeah.
Hell yeah.
There's a disclaimer. Sorry?
So you could go out tomorrow into a bank, get a $500,000 loan, go buy a house, and then send a load of these letters and be rid of the debt, but still have the house.
We come back to force here, because what they would attempt to do is to extort the physical property away from you, because there is a certain maxim of law of ownership, you know, the finders keepers kind of thing. So what they kind of do in those things is they try to hire people to take away the property away from you. It's all about ownership, physical ownership of something, right? Plus, I would say that they also own the deed, that you don't actually have the deed yet.
Right.
Okay, so it's a difficult situation in those sense. It would be different if you had a credit card and you'd gone out and bought something and they couldn't actually physically locate the item to try and repossess it, you know, during this period of redemption. Yeah.
But you were saying his was a home loan. Could they not try and take the house?
Sorry, I think his was actually a personal loan. No, he was actually wanting to get a home loan. So he was wanting to make sure that his credit card, I guess his debt history was clean. And I'll come to that in a minute, which is the cleaning part. Because obviously once you've actually gone through all this process and no one's been able to provide you with proof of claim that there is a debt, what they do is they discount it all, they sell it, and they report you as a bad payment. Right? But nothing actually happens to you. And so
you do end up with a bad credit rating.
What you end up with is a note at one of the credit reporting agencies that says this is a default payment, okay? Because their books didn't balance. So what you do is you write another letter. This is the final stage in the cleaning side of this. You write a letter to the credit reporting agency and ask for your credit history, and then you challenge them, okay? Because they have no idea, right? They're not even the third party. They're like the fourth, fifth, or sixth party here. So they have no idea of what's right or wrong. So you actually challenge them to provide proof of claim. And if they can't do that, they have to basically correct the incorrect record. And that's how you clean it up afterwards. Okay.
And if they choose not to for some reason, they just say no.
Oh,
so
they can't. I mean, even
can you challenge them and say, I want to challenge you in the courts and use the same process against them in the court?
You don't even need to go to court, actually. There are places that you can just sort of go and say, well, you know, this person is reporting. They're not allowed to incorrectly report things like that. Even a debt collector, if you ask them to stop bothering you, and they don't, every time that they bother you and don't provide proof of claim, it's instantly $1,000 fine. Okay, and most people don't know that either. So, yeah, it's very interesting. The disclaimer that I put on the bottom of this says, please note, incorrectly addressed mail shall be returned unopened and unread. Any and all correspondence from this point must be by mail only. John Doe does not authorize the recording of his voice at any time for any purpose, nor does he consent to being contacted by telephone, and shall enforce his copyright rights in all instances such as copyright infringement or trademark violation. No authorization for the use of John Doe TM, all caps, is implied, granted or permitted. John Doe, all caps TM, agrees to hold harmless John Doe, the natural flesh and blood man, for all claims and liability under private contract between the parties. So there you have the complete. They cannot enter into that at all. And basically what you have here in these situations is a failure to state a claim upon which relief can be granted. Okay. So we've done a number of those now, and it's been successful in every time, and not once have any of the credit card companies or the legal agents or the debt collectors been able to provide one instance or one iota of any evidence that there is any debt. And so we didn't actually do anything wrong. We only asked some questions. We said, again, here's the conditional thing. They've sent you a statement. They can't send you an invoice because there's no money, right? If you ask them for an invoice, they can't do it. So they send you a statement. And you say, okay, well, I'm happy to pay the alleged debt upon proof of claim that there is one. Right? You try and get these guys to provide proof that there is any debt. Forget it. It never happens.